come on the session this morning, and thanks to Mohan for facilitating this. I'll just get my slideshow going. My name's Amy Peters from Beneficial Trust and Will Company, and today's session is really to give you an update on some of the chatter around estate planning as a result of the 2025 Law Commission review that you may have clients mentioning in various conversations, but also to take you through some common client scenarios or questions that do crop up. So hopefully you'll find it a useful session. So we'll break the session up into 4 sections. I'll give you a little overview of me and our business. As I say, we'll talk about the Wills Act reform, the recommendations to update the world of estate planning, because we still have to comply with the formalities of the Wills Act 1837. I'll then give you some common client scenarios in terms of estate planning insights. So we hear a lot from clients who believe things like transferring properties to children during a lifetime, things like putting everything in a trust is going to sort all of their tax problems, and we know that's not entirely true. So kind of work through some misconceptions and some scenarios that you may well come across. And this is all about leveraging estate planning to really maximise your offering to your clients, to be able to give that holistic advice, and to be that central point of contact for your clients fundamentally. So, as I say, I'm Amy Peters. I am a chartered paralegal with the Chartered Institute of Legal Executives. I'm an affiliate member of STEP. I'm a full member of the Institute of Professional Will Writers. We have members of the team who are also members of the Society of Will Writers. We're partnered also with SRA regulated legal teams for any of our reserved activities. So for those of you that are maybe slightly familiar with legal services, we do have red lines in terms of where regulation sits, because sadly for us, we've got something like 22 regulatory bodies within the legal services sector at the last count, which makes life interesting. And as a business, we've been established for over 25 years. So I've been in this role for around the last 12 years. So in supporting around 80 active advisors, as well as a number of firms and sole traders, whether they're estate planning consultants, mortgage advisors, financial advisors, up to kind of large firms. So we're a small but perfectly formed team, in our opinion, and we're certainly kept busy. So, as I say, we work with a network of other professionals. So if the work that we do tips into complicated tax advice, so perhaps there is a high net worth client in the mix, then we can tap into our chartered tax advisors. If there's issues with or questions around mental capacity, then we work with quarter protection specialists, independent social workers, obviously financial advisors, mortgage advisors, protection specialists such as yourself, because all of the conversations we have are naturally intertwined with these various specialities. So as I say, over the last number of years of operating, we've built a really solid network, and we're fortunate to work with some really, really great people, which we're really pleased with. I won't dwell on this too much. This is just in terms of our ethos, in terms of how we work. We're very much about providing a personalised service to you as an advisor. So 80% of our work is from partnerships with advisors such as yourself, who either refer clients to us or take instructions directly from clients with our support. And we provide all of the back office support and document drafting, all of that kind of thing. But we're very keen on personalisation for clients, probably very much like yourselves, in terms of not forcing, a square peg in a round hole, making sure any solutions we provide to clients are personalised to them. And we don't kind of solve one problem and create another, hence why we like to work quite closely with other professionals to make sure we've got the full picture. We've got a pretty solid reputation after 26 years in business, 27 next year, which is scary. And also when we're working with you, we try and keep you informed in terms of progress and conversations as much as we possibly can. We do feel that working with us, you can diversify your offering with a level of ease. We don't have any interest in financial services. We don't have any feet in any other kind of financial services aspects. We just very much focus on estate planning, wills, trusts, lasting powers of attorney, inheritance planning, all of that. So there's no conflict of interest, anything like that. And as a provider, we're very much about information sharing, possibly a bit of oversharing, that in our view, this world that we operate in is something that everybody needs. There's plenty of business out there for everybody. Collaboration really is the key. So if we can help to educate and inform and share some useful messages, then it's to everyone's benefit, particularly to obviously clients' benefits. I had a message this morning from an advisor as their client has been referring to a TikTok advisor for some of their guidance. So I was watching a couple of their TikTok videos this morning. So it is a case of, making sure we're getting correct messaging out there, because there is a lot of misinformation. I'm sure some of you will have come across the same in terms of financial services, these financial influencers. So yeah, it's about making sure that the clients are fully informed, and we provide everything from straightforward wills to just discretionary will trusts, property protective trusts, HMRC TRS registration, lasting powers of attorney, some inheritance tax planning advice for business owners, cohabitation agreements, executorship and estate administration services. So pretty much anything that you can think of within this area. And as I've said, if it's something that just tips toes beyond our specialism, we probably know someone that can help. We've got a good network to lean on. So the Law Commission 2025 review and the Wills Act 1837. I should just say, if anyone's got any questions, please do chip in, because I can rattle on all morning quite happily. So do chip in. This is your session. So yeah, the Law Commission 2025 review, this was earlier this year, and this was a 500-page report. So any of you are struggling to nod off in these winter months, have a read of that. It's quite lengthy, outlining some recommendations to fundamentally update the Wills Act 1837, because as you can tell from the date, it's a fairly old piece of legislation about how we can make a valid will within England and Wales. And so the objective of the report was to support testamentary freedom, so to ensure that people's wishes could be correctly fulfilled and interpreted, to protect testators from undue influence and fraud. So we do appear to be in quite an era of predatory marriage, things like that. So there's certainly a case circulating at the moment that a daughter of a deceased person is highlighting, where her mother lived alone in a property and she was okay, but she was slightly vulnerable, and a chap started chatting to her over the garden fence, basically from the street, kind of chatting to her, talking to her. She was perhaps a little bit lonely. Anyway, within a matter of weeks, this chap had moved in with the mother. The mother had less and less contact with the family, so a process of isolation had really started. And before the family knew, this chap, mystery person, and the mother were married. Mother subsequently died without making a will, and so this mystery person suddenly found himself entitled to £322,000 of her estate, which was in fact her entire estate, due to the rules of intestacy, so the rules that apply when people don't have a will. So there's sadly more and more of these cases coming up. So again, this is part of what the Law Commission review is there to try and tackle, and also to bring clarity and coherence in the context of modern life. So if we think back to, 1837, we were very much kind of quill and ink and wax and parchment, and sometimes I feel we still are because we still have to kind of have so much pen and paper around. But life has moved on, things have changed, and some of the key recommendations included aspects such as support for electronic wills. So you'll hear kind of clients saying, well, I can do my will online for 50 quid and happy days, it's done and dusted. And you can give your instructions online, but unless that will is printed and signed with a wet signature in the presence of two witnesses, it's as if it doesn't exist. It would indeed be invalid. So again, it's about making sure clients are really clear about what is a valid will and what isn't. So if a client says, well, I've done mine online, that's certainly something to check with them, because that is an issue. Now, these are all recommendations, I should mention as well. So nothing has come into law as yet. Nothing has changed. These are suggestions that the Law Commission have put forward. The recommendation for electronic wills, I think, is fundamentally something we need to look forward to. But I do feel it's a little bit of a long way off. So we had the Power of Attorney Act 2023, and this was about modernising the lasting power of attorney process that came into effect 2 years ago, including part or full digitisation of the lasting power of attorney process. And we're still no closer to that. So I do think this is a little way off, but obviously it's something on the horizon. Just like we're all looking at AI and wondering if we'll all be employed in 5-10 years' time, we'll have a job. It's something we need to face and figure out how we can adapt to. Another aspect that the Law Commission wanted to review was the idea that marriage should not revoke a will. So at the moment, if you have a client and they say, right, I've done a will, don't worry, we sorted it all out before we got married, we need to check the will. Because as soon as someone gets married, it makes any wills they've made previously invalid. Now, without people realising that, unless the will states an expectation to marry within there, the marriage would revoke any former wills. Now, there's been some cases that have cropped up with this. For example, there was the case of the Monaghan family, I believe, a couple of years ago. A lady, just to summarise, she got divorced. She had 3 boys, I think. 1 or 2 were under the age of 18. And she thought, well, I've got divorced. My situation has changed. I need to make a will. So she made a will, very responsible. And then she met a new partner, and shortly after meeting her partner, she also sadly was diagnosed with cancer. Her partner very quickly moved in. I mean, I'm sure it was very fraught and intense circumstances, and married the mother. And the mother sadly died not long after the marriage, which meant that the will she'd made was invalid, the will that she'd made leaving everything to her 3 sons. And the new spouse was now entitled to the first £322,000 of her estate and half of anything over that amount. And her sons were entitled to the remaining half. So it would appear, unless they could come to an agreement subsequently, that the sons were effectively accidentally disinherited from her estate, which is unlikely to have been what her intention was. So the idea is that perhaps marriage should not revoke a will because it can create more problems than it solves. Something else that the Law Commission wants to look at is clarification on testamentary capacity. So currently we have to comply with Banks versus Goodfellow, which is a very old piece of case law. And the view is to align that with the Mental Capacity Act, which addresses capacity in a less black and white viewpoint, because in reality, capacity can come and go. So if you have a client and they've got fluctuating capacity and they haven't made a will or they haven't made a lasting power of attorney, just because they've already got an onset of symptoms, it doesn't actually preclude them from making a will, but it does mean we would need to get an independent medical professional to confirm they do have requisite capacity to give an instruction. So again, if you have clients coming to you seeking help in that situation, there are potentially things that we can do. So there's a view to update that. And they're also looking to potentially lower the age for making a will. So currently, you can only make a will if you're 18 years or over within England and Wales. And the view is to reduce that age to 16. 16 does seem very young, but then I'm in my 40s, so any age probably feels very young by comparison these days. But there is a view to look at that as well. Another thing that the Law Commission wants to look at is undue influence. So currently, a will can be challenged if it's not been signed correctly. Is the main reasons why a will challenge could be brought. It's either it's not been signed correctly, the person making the will didn't have the mental capacity to be able to make that will, or they were unduly influenced to do so. So somebody kind of forced them in some way, isolated them, preyed on them, preyed on their vulnerability, whatever it may be. But undue influence can be difficult to evidence. And it's the claimant, so the person bringing the challenge against the will, who has to evidence that that was indeed the case. Whereas there is a move for the courts to actually themselves state, we think there's some level of undue influence here, to again try and protect the vulnerable a little bit more. Things like ratifying wills in exceptional circumstances and expansion of the scope for rectification claims, because we do have a proliferation of DIY wills, and there's some absolute corkers out there that make no sense whatsoever. ChatGPT is incredibly rubbish at making wills. Perhaps, again, my job might be one that will going to be the first to go. I don't know. Perhaps that will improve. But it's, I've seen some absolute corkers. I can understand what the client is trying to get to, but the way that the law is currently positioned is that there needs to be kind of absolute clarity on what is within the will, how gifts are identified, how individuals, executors, beneficiaries, trustees are identified. And if there's any ambiguity, then the will can be deemed as invalid. So there's a view to kind of look at, well, how can the courts look to interpret the wills to try and ensure ultimately the testator's wishes are carried out. So the testator is the person making a will. And there's also they're also taking a look at the rules relating to witnesses and wills signed at the direction of the testator. Well, what does that mean? So again, when we have clients deciding, well, I can just make a will, I'll just get ChatGPT to do it. It's a straightforward will. I'm going to leave everything to my husband and then everything to my 2 grown-up children. And then I'm going to get one of my son's wives to be a witness and my neighbour to be a witness. And that's it. Job done. Easy peasy. I mean, there's a lot of things they haven't considered in terms of the drafting of the will, which we'll come to in a second. But in terms of witnessing, they've had their son's wife witness the will. And so by doing that, they've actually compromised that son's inheritance. It's invalidated his inheritance now. It's created a partial intestacy within the will. And so actually their entire estate goes to their other son, not between the 2 sons. So even when we get to the point of wills signing, that's where things can fall down. Or people don't sign the wills, which is even worse. And then it is as if they didn't exist at all. But they are looking to expand the rules as to who can be a witness and who can't. So that may expand further into partners of beneficiaries, so beyond spouses of beneficiaries and so on. So it will be interesting to see how many of these recommendations actually move forward. Government appears to be very busy with a few kind of wars, tax issues, black holes, whatever. So perhaps some of these changes will gradually creep forward. But unfortunately, nothing moves very quickly in law. So it can take some time. In terms of the statutory requirements, by November, there should be a response from the responsible minister about these recommendations. I haven't seen that yet. And a full response within 12 months, so by May. And then so it'll be clearer to see if the government want to take any of these suggestions, some, all, none of these suggestions or proposals forward. So I think it's good that this legislation, they're looking to update it. I think in the short term, it can possibly create a bit more confusion, thanks to the media, news channels, TikTokers, whoever, misinterpreting this as having changed. And nothing has changed at the moment. These are all things that are being suggested. So I thought that might be useful to go over, just because there may be aspects that your clients raise and you might think, well, is this true or not? So at least you've got this to refer to in the future. The slides will be circulated if they haven't been already, and I know Mohan said there'll be a recording provided as well. Any questions on that before we look at some client scenarios? All very quiet. Or gone off for a cup of tea, maybe, I don't know. Okay, so I thought we'd just go over some client scenarios and questions and queries that have cropped up, that we've seen in the last year or two. In terms of how many cases we see each month, it can be kind of 100 to 150 per month cases that we process. So it's not thousands and thousands. It's enough for us to be able to provide that personalised, tailored advice that, as I mentioned earlier, and it's enough for us to get a real depth and wealth of experience to share and impart with other professionals such as you. So one thing that comes up quite a lot, or has come up quite a lot, is where clients will say, well, I want to leave everything to my two daughters, but I absolutely don't want my son-in-laws to receive anything. I don't like them. I don't trust them. I think they're just after the family money. It's a really nice family dynamic, as you can imagine. So they'll sort of say, well, can I put everything? I'm just going to put everything into a discretionary trust. I've heard from my friend who's done it, that classic, that this will solve all of those concerns and protect everything. And so what I would say is these discretionary trusts can be very useful, but it's always about providing the right solution to the right client for the right reason at the right time. And so it can be beneficial for enabling, for example, parents to leave assets to children and to incorporate discretionary trusts within their wills, which fundamentally means that the trustees they appoint have discretion as to how those funds should be applied. So it's not absolute that each child will receive 50-50, for example. So if a divorcing child has a potential future inheritance, it's not clear as to how much that inheritance is. And there are questions around matrimonial law and potential future inheritances and how far that can go. But in terms of where a discretionary trust is included within a will, or perhaps there might be some asset settled during lifetime for whatever reason, maybe for tax planning reasons, whatever, as long as it's in a revocable gift, which we won't go into in terms of gift for reservation of benefit. But if there is funds within a discretionary trust, then the divorcing child, for example, has only the mere hope of appointment in their favour. The argument would be in a claim of that nature that there isn't a quantifiable, realisable value to be included in a statement of assets relating to the divorce. That's the theory of it. So is it that simple, and does it really work? So if we say to a client, well, just pop a discretionary trust in there that'll totally preserve it from accidental sideways disinheritance or divorce or whatever, So the argument is, if the child was a potential beneficiary, was there always an intention they would benefit at some point, is the question that would be raised. And should the court interfere with freedom of testamentary position of someone who's not party to the divorce proceeding? So the person who's made the will isn't subject to the divorce proceeding. So what right does the court have to tinker with their choice as to how they leave their assets, and what are the options in there? So there's something called judicious encouragement that the court could apply. I think it's maybe a back up the arm, an arm up the back kind of situation, a little bit of a thumbscrew in terms of, can the claimant spouse demonstrate that if asked, the trustees would likely immediately or in the foreseeable future exercise their powers or in some way for the benefit of the other spouse? So can the claimant, so the other side of the divorcing party, demonstrate that? And fundamentally, if a parental will trust is to be included as a financial resource in a divorce settlement, the court could make an order to indirectly twist the arm of the trustee to appoint the sum to the potential beneficiary that they could reasonably expect to inherit. But the trustees can ignore the judicious encouragement, and the court is actually powerless to enforce the trustees. It's got no means to enforce the order against the trustees as they are not party to the divorce proceedings. So that's why we talk about putting things in discretionary trust, because it can provide a bit of a shield, but with caution, because if a court's unable to enforce trustees to appoint to the other child, it may simply award a greater share of non-trust assets to the other party. So there's always a bigger picture with all of this, isn't there? So if you look at the trust in isolation, then yes, it could head off any future divorce claims, but the court could simply reassess any other assets and tip the balance in another way to try and equalise potentially the division of assets. Things like prenuptial agreements, I think, would be worth looking at as well. So with all of this, discretionary trusts are very useful where this is a concern, because it can act as a barrier in some instances, because the costs of going to court are very expensive. So it may be enough to head off a potential claim. The only thing to mention about discretionary trusts and wills as well is we always need to be mindful of the residence nil rate band allowances. So you'll all know, I'm sure, because I'm sure it's been done to death over the last year with all the pension reforms that you'll all have been subjected to. We'll all have the ordinary nil rate band of 325 and the residence nil rate band of 175, where the family home is passed to lineal descendants, which does taper away where estates start to exceed around 2.2 million. So if assets are passed via a discretionary trust, then the R&RB allowance can't be applied. So we need to sometimes offset how strongly clients despise their sons and daughters-in-laws versus how much they despise paying inheritance tax or not. So sometimes it can be a bit of a trade-off. But again, if you come across clients in this situation, they feel very strongly, it's worth us having a conversation with you or with the conversation with the client to see what we can do. Because with all of this, obviously you guys are doing a really good job of helping them to grow their wealth, getting them on the property ladder, investing, pensions, all of that kind of thing. But we don't want to leave everything else to chance. So in the event of them passing away, hoping everything's going to be okay is probably not the right route to take. So it's all about ensuring that people's wishes are carried out as far as possible. Now, there may be some situations where clients are particularly secretive to the extreme. Not only that they don't want anyone to know what's in their will or how they divided their estate, which is fine, it's completely confidential to them, but they don't want anyone to ever know what was in their will and how they divided their estate. And that's where things like fully secret trusts can arise. And it's where the testator, the person making a will, gives their property to the donee, but gives no indication that the donee is to hold their gift on trust. So the gift looks like an absolute and beneficial one, but in fact, the donee, the recipient, is bound by a trust obligation. So the will might look that they're giving everything to Fred, their neighbour, but actually Fred, their neighbour, has got a binding obligation that sits alongside or underneath the gift, stating how the gift should actually be distributed. And so this, you may have come across this where there's like media reports that, a celebrity or a famous person has, left a large estate, but has left nothing to their children, or left nothing to their wife, or left everything to their friend. And that's likely what could be the case, but it's potentially that secret trusts are involved. They are complicated, they are quite rare, but they're quite interesting, aren't they, in terms of the interesting lives people lead that would make them feel they need this. So a fully secret trust is where the recipient of the gift is identified, but nothing else. A half secret trust is where the will declares that the donee or the recipient is to hold the property on trust, but the trusts are not expressed in the will, but have been communicated to the trustee in their lifetime. And the issue with this is, well, what if the person in receipt of the asset actually says, well, I'm going to keep it? No one knows because it's a secret trust. So caution does need to be applied, and there does need to be some structure that sits around that, and definitely a professional involved. And the enforcement of secret trust does seem to be in conflict with the Wills Act 1837, because we're not really clearly stating what should happen to the gift, but they've been enforced by the courts as they're not trusts created by the will, but trusts arising outside and independently of the will. So again, if you happen to come across a client with an interesting situation, or they state, well, they just don't, they're very secretive, then there are things that can be done, but we need to kind of tread carefully with that. So yeah, that's an interesting one. Any questions so far? Rattling through. Another thing that comes up is life interest will trusts. So this might be something that you've come across or clients have spoken to you about. Clients may be seeking your support on, whether you're taking instructions with us currently or referring clients or whatever it might be. These commonly arise where for married couples. So this is where you've got Mr. and Mrs. Let's say the property is their main asset, or they want to separate their property from their other assets to preserve the residence nil rate band. So they want to protect that, and then they might want to put a discretionary trust or flexible life interest trust for their other assets, but we'll leave that for another day. So we're talking about the family home in this instance. So they could have a straightforward will, and they say, well, right, we're going to leave everything to each other and then to the children, which is fine. And for some people, a straightforward will, may well be fine. But what about if one of them dies and the other spouse remarries? Think back to the earlier example, and forgets to make a new will. Then the new spouse is suddenly entitled to a large proportion of the estate, and their children could be accidentally disinherited. Or what if we've got a blended family? So we've got Mr. and Mrs. Mr's got children from a previous relationship. He says, right, I'm going to leave everything to Mrs. She'll make sure my children are okay. Mrs. is thinking, I can't stand my stepchildren. The minute he pops off, I'm going to completely disinherit them. So, I'm not saying it's that blatant. Sometimes it is. But it's all about creating protection for a surviving spouse, but giving absolute certainty as to who would ultimately benefit from the asset after death. So rather than them giving the house to each other outright on first death, they're going to split the way the property is owned from joint tenants to tenants in common, and the first person to die is going to pass their house via a life interest trust. So the surviving spouse will have be the life tenant. They will be able to live in the property for the rest of their life, move, upsize, downsize, whatever. but the deceased's share is defined as going to their chosen beneficiaries, regardless of choices that the surviving spouse may take later on or circumstances. So if the surviving spouse subsequently goes into care, the deceased person's share isn't going to be used to pay for their care fees, which sounds a bit harsh, but that's the reality of it. It's not a deliberate deprivation of assets because the person who dies not deprived themselves of any assets. They've just chosen not to pay for the surviving spouse's care fees. So that's often where we see life interest trusts and property protective trusts is what they're known as in wills. And for married couples, it's fine because we've got the spousal exemption, so no inheritance tax until second death. The residence nil rate ban can still apply because it's an immediate post-death interest trust rather than a discretionary trust. So happy days for a married couple. These do not work for unmarried couples because there isn't the spousal exemption because they're unmarried currently. I mean, this could all change, you know, in a week or two. And the issue with it is if we create a life interest for an unmarried partner, then the inheritance tax aggregates in the survivor's estate, but the asset doesn't. So we need to be mindful of what other assets the surviving partner may have. It could potentially work if they haven't got anything and we're under the IHT allowance and they don't need the R&RB. But life interest trusts are not ideal for unmarried couples because it can create unintended tax consequences. There could be a potential loss of the residence nil rate band as well. So if the first person to die has got children from a previous relationship, but they leave the property on trust to their unmarried partner, the first person to die's R&RB could be lost as well. And obviously the unmarried partner wouldn't have R&RB because they're not classed as stepchildren. So there are ways around it. So where clients say, well, we're not married, we've got no intention to get married, it is more tax efficient if they are married, let's be honest. We don't want to get married, been together for 10 years, 20 years or whatever. I still want to ensure my partner is taken care of, but I do want to make sure it's my children that ultimately benefit. Then we kind of go back to something like a discretionary trust that we could include in the person's will, where they leave instructions to the trustees to allow the surviving partner to be loaned the property to continue living in the property. We can look at things like nil rate band discretionary trusts to try and maximise tax allowances. So those tax allowances are not kind of lost and we don't have a double taxation on the estate. Or we could gift the value of the residence nil rate band to children immediately on first death as an undivided share. Now, some of this may be creating a light bulb moment for some of you. Some of you might be thinking, what on earth is she talking about? And it's just all about how, depending on different client situations, different scenarios, it's not a one-size-fits-all approach, but there are solutions we can provide for. So if you've got couples that want to provide for each other, but want some certainty as to who will ultimately benefit from their estate, then trusts are a route we can potentially look at, but they need to be tailored for individual solutions. It's not just a carte blanche approach. So married or unmarried couples, always a clear distinction. Be interesting to see if that changes in the future. Any questions? Rattling through. Now, when we make wills, obviously the idea is to create some certainty as to who will benefit from an estate, about identifying gifts, identifying beneficiaries. But for a number of clients, some days many clients, it's as much about who they don't want to inherit as much as who they do want to include within their estate. So it's difficult. So when there are family disputes, and you may come across this, and and clients, you're going to be the first point of contact for many clients who, whether, as you say, you've done a mortgage or an investment or a pension or anything like that, have appointed yourself, whether you want to or not, as the kind of single source of truth and their main point of contact for all planning thereafter. And so that includes not just people's financial interests, but naturally it will expand to their family dynamics. And where there are people that a client doesn't want to benefit from their estate, then there are a number of routes that they can take. And the straightforward route would be to exclude somebody within a will. That's kind of the very basic approach we would take. And that's where we would simply state within the will, I exclude my son, John Smith, for the reasons outlined in my letter to my executors. We wouldn't include any reasoning for that exclusion within the will, because after a grant of probate has been obtained, the will is a publicly available document. It's a whole other story about fraudulent estates and stuff to do with that. But because the will becomes a publicly available document after death, we don't want to include any libelous claims about John being a bit of a scallywag and causing all sorts of dismay and problems for their parents or whoever. So we just need to put a broad statement and or a very general clause, and then encourage the client to write a statement outlining the reasons for the exclusion, but also the reasons why they've included particular people. So it may be they've got two children, one who's a bit wayward, and one is disabled in some way. So they've chosen to exclude the wayward one and leave everything to the vulnerable child because they're never going to be able to support themselves. They're going to need additional financial provision, and all of this can go in that statement. Now, and that could be it. It is possible for clients to go one step further and actually say, well, I really want to try and head off this claim. This person's a real troublemaker in their opinion. I think an exclusion is just going to light the fire even more. Now, we can't remain silent about not including a person who could make a claim on an estate, which is the listed people here, because then it could be viewed as an administrative error by the court. So we need to be upfront with who we're including and who we're excluding, so there can be no misinterpretation. And it may be that a forfeiture clause could be the way to go. So, for example, I leave John £10,000, but if he brings any challenge to my will, then that £10,000 is off the table, and it's kind of all knives out kind of situation, metaphorically speaking. So that may be a way, and that may be just enough to head off a claim, because to bring a claim, it's several £1,000s in legal fees, potentially court fees. Maybe it's just best to take that legacy and leave well alone. It can be enough to put people off. And then going back to the earlier point about what about a discretionary trust? So we perhaps name, 2-3 people within the discretionary trust, but we leave directions to the trustees as to how they should actually appoint those legacies out in practice. And they remain confidential to the trustees infinitum. So perhaps that is a way to go. So it can be difficult when you come across families who've got fractured relationships and so on. But again, this is all about, we do all of this planning during lifetime. We do all of our saving, pay off our mortgage, want to leave something to the children, hopefully, maybe not. But we just think, well, everything will hopefully be all right. And it's why it's really important to encourage clients to get this planning in place, to get their wills in order. Something that also comes up is about guardianship. So if you have a couple, they've separated, it's acrimonious, and you're taking the instruction from, let's say, the mother, and she doesn't want the father to have anything to do with the children if she dies. Over my dead body, he's not going to have the children. I want my mother to look after them. Then we do need to broach the parental responsibility aspect. So parental responsibility does arise, obviously, if there's a biological mother, a biological father, as specified here. So if married to mother at time of child's birth, registered on birth certificate as father, parental responsibility agreement in place, whatever. Step parents via a parental responsibility order, adoptive parents, guardians appointed via will, special guardians, same-sex parents can all have parental responsibility, and it can be down to the family court. And a guardianship created by will can only take effect if there's no other person with parental responsibility that survives the deceased. A child arrangement order was in place in which the deceased was named, or the person who's passed away was the only or last surviving special guardian. So it can be a difficult conversation to have where couples are separating, and as I say, it's quite acrimonious. So it's as difficult as it is always better to try and get them to agree to some extent, or to it may be that father or mother wants to absolve themselves of their responsibilities now during lifetime, remove any doubt about it, which they may well want to do, and then the guardianship appointment within the will could take effect. So it's a strange one, but it is something that does crop up. And then just quickly, because I'm mindful of time, we've got the silence at 11, haven't we? Just a quick one on lasting powers of attorney and advance directives. So the will is an entirely altruistic act for the benefit of other people about what happens to someone's estate when they pass away. A lasting power of attorney is about us appointing people as attorneys to make decisions for us, either at our request in relation to property and affairs, or if we've lost mental capacity for our property and affairs and our health and welfare. And sometimes when we're speaking to clients, they'll say, well, I'm just going to do an advance directive. I'm not going to do a lasting power of attorney for health and welfare. And that is fine. But an advance decision is a legal document where clients can outline their wishes regarding specific medical treatments. So whether or not in certain situations they would want specific life-sustaining treatments. And that's it. That's as far and as an advance directive goes. A lasting power of attorney has wider powers for someone the donor trusts, so the attorney, to make other decisions about their care. So diet and routine, consent to surgery, where they should live, much more far-reaching. But that's not to say a client can't have an advance directive and an LPA for health and welfare. So it may be that the clients are adamant that they want to specify themselves about consent to life-sustaining treatment or not. They don't want to leave that up to the attorneys, but they do want the attorneys to make decisions about daily routines, medical care assessment, that kind of thing. So they could have both, but we need to reference the advance directive within the LPA. So if we don't, the one made most recently will take precedence. So if we do an advance directive, then we do an LPA, we don't reference the advance directive, the LPA will take effect. So it's just a bit of a random thing that sometimes comes up where people are unsure of the differences. So there are some differences. An LPA for health and welfare is, in my view, a bit more far-reaching and covers a lot more. But again, it's down to clients' individual preferences as to how strongly they feel about certain situations. We can only present out the options to the clients. It's up to them to make some of these decisions, but an informed decision based on being presented with the correct information, which hasn't come from TikTok. So leveraging estate planning. From your perspective, it's about completing the missing piece of your client's planning. Again, whether it's that you want to start taking instructions with our support and us providing you with all the back office and the document drafting, or whether you just want to work in partnership where we can, chat through particular cases. What I would say as well is do remember, we've worked with the network for a number of years and we really, really value the relationship. So don't feel you can only pick up the phone if you've got an absolute case to send to us, or an instruction to take. If you just need to chat through a situation, or if you've got a client who's come to you for some advice and you're not sure how to signpost them, do just give us a call or pick up the phone, because we're more than happy to support you. And as I say, it is about ensuring that people have the right information, whether they ultimately come to us or not for their will or estate planning. I feel very passionately that people have the correct information. So if ever you just want to chat through some of this stuff, please do reach out, because we do come across situations when more than a simple will is required. And in fact, a straightforward will can cause more problems than it solves. If we've got, second marriage issues, blended families, business owners, wayward children, vulnerable beneficiaries, we particularly need to make sure they're taken care of. Estranged family members, care fee contributions. We can talk about care fee contributions. We cannot deliberately deprive the state of assets. We need to be very clear about what we can and can't do. Likewise, I'm afraid there's no avoiding paying inheritance tax, really. We just need to maximise our allowances. So it's about ensuring, as I say, clients have that clarity, they have that information so they can make informed decisions. And so they still keep coming back to you as their trusted contact, because you've worked hard for that client and you want to retain them as much as you possibly can. So 7 minutes to go. Any questions? I appreciate we covered quite a lot there. Stunned silence. We're all there. Oh, Dan, have you got a question? Raised your hand, or was it a high five?
Hiya, sorry. No,
Hello.
I put a couple of chats in the typing them. My apologies. I didn't realize you wanted me to read them out.
Oh,
First
sorry.
question I had was, will a copy of the slides be available, please?
Yes, absolutely. Yeah, they will. Yeah.
Excellent. The subsequent question I had was, could you please just outline? I mean, you've done a great presentation there and really technical. I've actually done my JO2 trusts exam, so a lot of it was really insightful as a refreshment. But could you please outline how a relationship with beneficial trust and will company and the advisor would work? If, say, for example, the advisor was managing the investment vehicle, but obviously needed a bespoke trust that, say, the life offices don't offer off the shelf,
Hmm.
or something that goes in a will or an IPDI or something like that. How does the relationship work from the point of me contacting you or your colleagues and trying to generate the relationship there? Because I've had a look at the website and I don't really want to be a fully fledged estate planner like I've seen you advertise.
Yeah, no.
But I don't
No,
want the full responsibility of advising on setting up the trust, etc.
yeah, no. And that's where our introducer option really comes into play. So where if you've got that client situation, sometimes it can be best for us to have a meeting with you and the client just to talk through some options. Obviously, for us to have a separate conversation with you as well. We do have introducer referral forms, which we can provide you with as well. But yeah, in terms of trust templates, it's something we're working on with another firm in terms of junior general investment accounts and so on, in terms of gifting into those and trust structures that fit around it. So it is a case of just having an initial discussion with you in terms of what the client scenario is, and then working with our trust specialist to come up with a trust document or a trust template, and then figuring out if it's an introduction to us and we need to invoice the client directly, or whether the client needs to pay Julian Harris and so forth, and then to give you a referral fee basically as a thank you. So often it's as simple, Dan, as just having that initial conversation as to what your challenge is and if it's something we can potentially help with.
Brilliant. That's really helpful. Thank you.
All right, okay. Just seeing the chat now belatedly. Any other questions? As I say, I know it was a little bit technical with some of it, but it's always keeping in mind the client scenarios that you come across. What is it that the client's trying to achieve? What is it that's important to them? How are we factoring that into their later life planning? What happens if they lose capacity? What happens if they pass away? Are we making sure all of this effort we've made with them during lifetime is actually passed on to those that are going to benefit? Are we maximising tax allowances? Are we managing care fee contributions? Not avoiding them, we're managing care fee contributions. It is a reality we have to live within. But it is just working with you as cases crop up, and often that's where the relationship starts. As I say, we're quite a small team, so you would get to know all of us here in the office, whether you want to go down the road of taking instructions, or you just want to introduce clients to us, or you just want to talk through a situation and sense check from somebody else who's a little bit removed, whether the direction of travel you're going down makes sense, because sometimes it can be a bit lonely out there, can't it? So yeah, just always get in touch. You'll have our contact details, email addresses, phone numbers on the slides, and I'll make sure they're available as well. Okay. Any other questions?
Hi, Amy. I just wanted to check, are you able to provide CPD on these at all, or for the people?
If one of you or all of you can just drop me an email with your Mohan, if you can just drop me a full name of attendees list, we can send a CPD certificate if that's helpful.
That's fantastic. Thank you.
All right. Okay. Well, as I say, do reach out if any questions or queries arise. We're always available just to talk these through on an informal basis. And obviously, if there's some work we can do together, then we're always happy to collaborate. But yeah, I hope that was useful.
That's great. Thanks, Amy. That's really informative. Really appreciate that. Thank you.
No problem.
Always enjoy listening to your webinars.
Yeah, great. Thank you. Yeah, we do host regular open webinars on a quarterly basis. So do register for those if you want to come along. Yeah, just use the resources. They're there for you. Okay.
Great.
All right. Great.
Thanks a lot, Amy.
Thanks so much then. Thank you.
Bye.
Thanks. Bye.